Two works, one thesis. International Corporate Personhood by Kevin Crowe and the Medellin Manifesto on Transnational Value Chains by the Medellin Group. Together, they ask how international law should see and govern the most powerful bodiless actors on Earth. Crowe's subject is the International Corporate Person, the ICP, a trans-border legal personality holding an expanding arsenal of rights that belong exclusively to it and generating private rules that increasingly govern everyone else. It is a person composed of persons, fluid in form and in ownership, transcending states yet receiving its legal form from them. It overlaps at times with the individual, at times with the state, and accrues rights available to neither. 5 vignettes open the book. In Urbacer versus Argentina, a tribunal read a human right to water into Argentina's obligations, but found the corporation contracted to deliver it under no duty to do so. Exxon met climate investigations with civil rights lawsuits, claiming a political right to silence. JHO laundered over $1 billion through slapdash offshore shells. Apple used polished versions of the same technologies, including Irish subsidiaries that elected statelessness, to keep $250 billion beyond any tax collector's reach. And Airbus bought its way out of prosecution with a €3.6 billion deferred prosecution agreement, an immunity only legal persons can purchase. Corporate personhood then develops in 3 phases. In the magistrate charter phase, before 1850, incorporation was a sovereign grant, a privilege given for a purpose. In the public charter phase, from 1850 to 1945, general incorporation laws spread, and the corporation became an ordinary tool of commerce. And in the personhood phase after 1945, a concept forged in American constitutional law went international, animated by tribunals and treaties in an era of interdependent globalization. Then comes the crucial twist. The ICP does not merely receive this law, it authors it. Corporate interests hold consultant and observer status inside UN processes. The WTO's TRIPS agreement was drafted to the specifications of a corporate lobby, and CEO preferences travel into treaty positions through political spending. The ICP is a constituent of the very legal order that claims to govern it. The descriptive half culminates in the book's core finding: 22 judge-made and text-made rights and privileges available to the ICP and to no other international legal personality. They sort into 2 categories. Active rights are substantive and shapeable through the ICP's own agency, the right to sue sovereigns, to set intra-firm prices, to lobby. Passive rights are procedural, the ICP as a legal platform to which possibilities can be assigned. The normative half begins by refusing analogy. The ICP, Crowe writes, is not cleanly analogous to anything. He adopts Philip Jessup's transnational method instead: begin from human problems, not from legal categories. 2 such problems organize the theory: constituency, whom does international economic law actually serve? And sovereignty, which ICPs deploy as a strategy, invoked when useful, dissolved when not. A chapter on the public-private delusion shows, through insurance and state-owned enterprises, how the line every argument relies upon dissolves under inspection. The theory itself draws on Hume and Hofeld. Understand the ICP as a bundle of sticks. It is not animated by any single family of rights, but by a bundle limited liability, cross-border contract, suing sovereigns, political speech, each stick separable, each assignable. From there, the prescription: grant the passive sticks for problems that are genuinely universal, withhold universalized active sticks, which the ICP shapes through its own agency. And where new sticks accrue deferred prosecutions, layered taxation, transfer pricing, direct liability should follow, without the shield of the veil. The conclusion names the status quo: corporate sovereignty as sword, state sovereignty as shield. The more powerful the ICP, the more freely it shifts between public and private to escape liability. Crowe's proposal: tort law should address obligations, criminal law should address aspirations, and neither sovereignty nor veil should stand between human problems and their resolution. Because the ICP remains the most flexible and adaptive personality in international law, finely suited and underutilized to realize radical change in environmental protection and the distribution of wealth. The book theorized the corporate person, but the person, it turns out, is only the most visible node of something larger. In 2023, 12 scholars convened in Medellin, Colombia, to chart what comes next, extending the argument from the corporation to the chains it moves through. Global value chains have been heralded as the new world of trade, yet their relationship to international law is amorphous and chronically ambiguous. Building on the 2016 ICP Manifesto, the group proposes a rename with consequences. Not global value chains, but transnational value chains, TVC legal creatures built primarily out of private contract law. The cross-cutting question: what is international law equipped to regulate, and what is escaping its view? Who participates? Lead firms coordinating production across states, suppliers bound by cascading contracts, unions, financiers, consumers, states, even nature. International law's traditional list of subjects cannot account for this cast. The corporation is the elephant in the room, a generator of private normative orders, an interpreter of public ones, and an enforcer of both. How much is invisible to international law, and much is invisibilized? The group identifies three invisible economies: criminal economies, whose laundered value enters legitimate chains; informal economies, where work happens without contracts or protection; and domestic economies, family and care work, largely by women and migrants, uncounted entirely. Tools of measurement decide what is visible in international law and what is not. The aspiration: research that finds the public within the private. The categories of private and public law, the group argues, alienate practitioners, academics, and concerned parties from social reality. The manifesto is an invitation to lawyers, economists, sociologists, and supply chain scholars alike to map what international law can reach and what still escapes its view. International corporate personhood and the Medellin Manifesto. One thesis: bring the bodiless into law's view.